The first thing I guess I'll just mention is I'm not a lawyer, and we've we've worked extensively with a couple of lawyers over the progression of eosDAC. So this is just all stuff that I've kind of picked up as we've progressed in my career before. So from my perspective, the main issues that a DAC needs to consider, I think first of all, like any activity that a group of people are doing, is just the inherent riskiness of it. So for example, the magnitude of the financial value that is being kind of transacted or in any way transmitted in relation to the activity. So if a DAC is a group of people that's just coming together to do an activity that's not really financial in nature, or where there aren't really financial sums going back and forth, then that by its very nature reduces the size, certainly, of any kind of financial loss that could result to any party as a result of what the DAC is doing, and therefore that kind of minimizes the financial exposure to the people who are working within the DAC. So that's when we're speaking within kind of the area of considerations that we would call liability. So the liability for any decision that the people involved in the DAC had taken that might result in a financial loss to someone else. So just the overall size of that is the first consideration. And then separately, you would have sort of considerations around other types of liability that's of a non-financial nature. So, you could, if people are working together and there was a relationship between any of the parties that could be considered employment, for example, then there's a whole set of considerations around that. You can even get into some issues that I think the lawyers call like tortious liability. So that's when if there's any malpractice anywhere that resulted in somebody being harmed in some way, and that can be a very broad area of law. So I think the first, what all of that is kind of to say is that the first legal consideration for a DAC is just an overall assessment, or even a sense of how risky the actual fundamental activities are, and also of what kind of size they are, including even any kind of employment questions. Because even if a relationship between the DAC and a person could be ever construed as employment, if it's of a very small size, if it's only a couple of months' work, or the value of the work is low, then that in itself also limits the kind of eventual seriousness of any claim. So yeah, I think that's the first thing, is just looking at what are the actual activities that the DAC is going to be doing and how large are they. There could be a whole set of issues around contractual disputes. So the DAC and another person agree to do something together, to create something together, or the person kind of is a contractor to the DAC. If that relationship doesn't work out, then one or other party could say that the contract between them had not been honored. And so, for example, one or other party might try not to pay, or try not to deliver the product, for example, the piece of work. So that would be kind of contractual disagreements that could arise between people working together in a DAC. You could have a scenario in which there were IP questions. So like in a technology startup, if somebody had developed a product or had developed IP and it wasn't clear who that would belong to, even if something's open source, actually the kind of IP can still actually belong to someone, although the enforcement of that is different when it's been made available under an open source license. But so IP questions could come into it, like if it wasn't made clear who would be owning that or developing that. That's kind of intra-DAC stuff that I talked about up until now. Then you have everything related to the customer, so or to what any kind of external party that technology startup or DAC would be interacting with. So let's say they had a customer that they had agreed to create something for, and there was a dispute between them about the quality, or let's say it went wrong. And I mean, the worst case scenario is always that somebody suffers a demonstrable financial loss as a result of a contractual dispute. So let's say that technology startup had said that they were going to deliver something on time, and that technology startup was a DAC. Let's say that they said that they were going to deliver something on time, and it wasn't delivered on time, and then the customer could actually show that that had materially impacted them in some way. Then there could be a claim from the customer to the DAC. And then we get into the set of questions around, well, who would the customer actually be coming after? Because in a company, it's clear the company would be contracting with that customer, and the customer would have recourse to the company. In a DAC structure, that's a little different. So that's one of the things that we have to try and solve when we're coming together as DACs right now in this kind of era prior to there being widespread judicial and kind of regulatory recognition of DACs as an actual structure unto themselves that would be included, say, under company law. So really, I would say, like, you know, anything that any company or any group of people working together could encounter, it's exactly the same set of issues that a DAC would encounter. It's just a little bit less clear in a DAC who's responsible for what. That's the difference. The whole reason why company structures emerged was in order to make it clear that when people came together to do work, they were coming together as a group doing work. It wasn't like this person doing that and that person doing that. It was them as a group. And that's why then, for starters, financing was capable of being made into the entity itself rather than to the individuals in question. But also then liability was able to be apportioned to the entity itself rather than to the people in question. So it's that set of issues that is different in a DAC versus a company. It's not the set. What is not different in a DAC versus a company is just the types of things that could arise in the world that would give rise to some type of a legal dispute. They could be necessary for, it depends on what you want to do. If the group of people coming together wants to make use of structures in the real world, like banking or insurance, or if in order to procure certain services, they need to present themselves as a company entity rather than just as individuals, like, for example, procuring servers, or even a physical address, for example. Those are all things that traditional entity structure makes more possible. If people don't want to make use of traditional structures like the company structure, or the charity structure, or the trust structure, then they kind of would be perceived by the outside world more as individuals. So the individual would have to go away and get the server. The individual would have to use their home address. That's one sort of consideration of whether a traditional structure is needed. The other, I mean, the main reason why sometimes people turn to those structures is to make how liability falls more clear. So if you don't set that out ahead of time, and if you don't make use of the provisions under the company law of your own country that delineate how liability is construed within a group of people working together, if you don't make use of that and you instead just decide to work together as a sort of loose association of people, which is what a DAC would otherwise be considered by the law to be, then you run into the possibility that any single individual within that group could be held responsible for the whole group's actions. And that might be a lot for that one person to bear in terms of financial liability or in other ways. So that's really the two sides of the equation. On the one hand, you might want to, as a DAC, you might want to make use of traditional real-world structures like companies, trusts, charities, in order just to do the things in the real world that you want to do, like have a bank account or get insurance or whatever. On the other side, you might want to make use of those structures in order to use the legal framework that exists within your country so that it's clear where liability would fall. If you don't care about any of those two things, and you know, I think we're trying to build a world in which we perhaps don't care about this thing. So, you know, it's great that crypto more and more, you know, we now are able to get our servers without going through fiat. You know, we're able to, I mean, there's probably more and more insurance options coming up that are entirely crypto native. And if for some reason it's not going to keep you up at night to worry about the liability considerations of your particular venture, then that's great. And I think it's perfectly possible to stay away from traditional real world structures. And I think that's kind of what we all would prefer, those of us working in crypto. I think it's only when you stop being comfortable with that, you know, where either the magnitude of what the group of people are doing is too great, or the riskiness is too great, or to structure yourself in that way means that you would be preventing certain people from taking on leadership positions within the organization. Like at a practical level, I think that's often what ends up happening is, you know, you might have a few people in the DAC who just don't care about the legal liability, but then you kind of maybe would only ever attract people who maybe don't own assets themselves or don't have kids, or, you know, are just sort of for whatever reason by their nature pretty risk tolerant. And then you end up maybe with a DAC that just doesn't include people who maybe would want to have more safety precautions in place. So I think these are the types of pros and cons around traditional structures or not. So there you have to consider what it is that you want to do, why it is that you're setting up a legal entity and what you want to do. If what it is that you want banking, for example, I think that some jurisdictions that might be, I mean, we set up in Switzerland, which we thought was a good jurisdiction at the time. Estonia, I think, is a jurisdiction where it's easier to access banking. There are some crypto-friendly jurisdictions where actually banking is not so easy, like the Bahamas and some of the offshore islands, because they have a strong corresponding banking system there, where in the end those banks still have to fulfill US rules. So I think the first thing is that you have to ask, why do I, is it because I want to access banking, for example? And then that's one set of considerations. If you just want to be registered somewhere and have a physical address, it almost probably doesn't matter where you're located. You can just set up as a company that then is attached to the DAC. But I think the most exciting real answer to that is one of the projects that we're working on is Liberland. That country has the aspiration to create a company law system like exists in all developed countries of the world that is already specifically geared towards DACs. And so any group of people that wants to register as a company in Liberland will already be set up as a DAC, an on-chain organization using a DAC factory like initiating system that creates their DAC on a blockchain, and at the same time delivers a company law structure and an enforcement mechanism. So like an enforcement mechanism is like a court. In this case, it wouldn't necessarily be a court, but mechanisms by which people could resolve contractual disputes and so on, that are all basically designed for companies formed as DACs. So I would say that the best jurisdiction is going to be Liberland, but that's not yet up and running as a jurisdiction where you can domicile a company. But within medium term, we expect that to be the case. In eosDAC's case, we kind of decided that because, especially at that time, we were an active block producer, a relatively unknown quantity in terms of the types of activities that companies do, that was kind of high enough risk that it was worth putting in place some extra protection. So I should actually mention that the first level of how eosDAC defines the responsibilities and the rights of its members is in our constitution. So anybody who holds eosDAC tokens and who then wants to use those to vote needs to register as a member of the DAC, and that's an on-chain action to read the constitution and to agree to its terms. And the constitution defines that all token holders have equal rights with each other. They also have equal responsibilities with each other. It talks about how custodians are not responsible for the decisions made by the DAC personally, and so on. So there's already and the constitution is our user agreement. It's the agreement it's a contract between everyone involved in the DAC that sets out the terms on which we are working with each other. Then to think about how we interact with the outside world. In eosDAC's case, we decided to create the concept, or to use one service provider, a single private company that is replaceable, that can be switched out at any time. That company contracts with the outside world, procures whatever services we need in the outside world, according to the stipulations of the DAC, what the DAC wants, and then delivers them to the DAC for a fee, for a profit. So it's an arm's length commercial relationship. It's a workaround structure. We would prefer not to have any kind of point of centralization within the structure. But what we feel mitigates against the centralization is the fact that it's still the elected custodians of the DAC. So those custodians are elected by eosDAC token holders. It's still the custodians of the DAC who get to switch in or out that service provider at any time, for really any reason. So that's how we've structured it, and yeah, so far I think we've been happy with that.